everybody, and thank you so much for taking time out of your busy schedules to come and enter into this discussion with you. On behalf of the Kroc Institute for International Peace Studies and the Klaus Center for Civil and Human Rights, I am Jen Mason McAward. I'm the director of the Klaus Center, and I teach at the law school. This year marks the 70th anniversary of the Convention on the Prevention and Punishment of the Crime of Genocide. And for all the hope in the post-World War II era, the intervening years have seen genocide in Asia to Central America to Africa. 70 years hence, how should we think about the Genocide Convention, its promise and its pitfalls? And to help us think through these issues, we have two distinguished panelists, Professor Ernesto Verdeja and Professor Alejandra Gonza. I will introduce Professor Verdeja, and he will share some of his thoughts with you, and then I'll introduce Professor Gonza more thoroughly, and she can share her thoughts with you. And then, once they're both done, I will open up the floor for questions and conversation. So Professor Ernesto Verdeja is an associate professor of political science and peace studies here at Notre Dame. He earned his doctorate and master's in political science from the New School for Social Research in New York City. He's a core faculty member of the Kroc Institute, and he's also the director of the undergraduate program in peace studies. And among his many affiliations on campus, he's also a faculty fellow at the Klaus Center for Civil and Human Rights. In addition to all that, he is also the executive director of the Institute for the Study of Genocide, which is another co-sponsor of today's event. His research focuses on large-scale political violence, transitional justice, forgiveness and reconciliation, and trials, truth commissions, apologies, and reparations. And as if that was not enough, he also won the 2018 Sheedy Excellence in Teaching Award, which is the highest teaching honor that Notre Dame's College of Arts and Letters has to offer. So welcome, Professor Verdeja.
Thank you. Thanks so much for that kind introduction. So I'm going to be speaking a little bit about the origins of the Genocide Convention, and I'm going to lay out what I think are some of the challenges of where we are right now. And the idea behind this panel is to keep our comments relatively short so we can actually have something of a conversation and have a Q&A. So that's kind of the aim. I'd like to begin by acknowledging that this educational institution is in fact located on the ancestral land of the Potawatomi, who over time were forcibly removed from this region by European colonialism and American expansion. I think it's important to acknowledge these things because very often we spend time thinking about atrocities and injustices that are committed elsewhere, but they start at home, so reflection begins here. So I'll be speaking about the UN Genocide Convention, or as it's formally known, the Convention on the Prevention and Punishment of the Crime of Genocide, which was adopted by the United Nations on December 9th, 1948. So that's the 70th anniversary that we're discussing here. And it went into effect in 1951. The convention itself was developed and drafted ultimately really in response to the Holocaust and devastations of World War II. But the person who coined it, Raphael Lemkin, a Polish Jewish jurist, understood that genocide was a crime that had occurred throughout much of human history. It actually had deep historical roots. And he developed the term genocide by drawing on two different words. He drew on the word genus, which from the Greek means race or group, and side from caedere in Latin, which means to kill. And what is novel for Lemkin, and what is important about the crime of genocide, is that it's not merely mass killing. It's not only the killing of a lot of people, but rather it is really intentional group destruction. It's about the destruction, not just repression, but the destruction of groups as such, with the aim of destroying the group, ultimately. Genocide was not a crime at Nuremberg, even though the term already existed, had been coined in 1944. It had come up in some of the indictments and some of the trials at the time, but it wasn't one of the formal crimes at Nuremberg. But in fact, the convention that we look at today, and I'll just put up a couple of slides here. Well, okay, that's us. So those are the people on the panel. The convention today, here I'm drawing on Article 2, which is the formal definition of the crime of genocide according to the UN Convention. And this is really the operative or determinate definition that's used in international law, and to some extent among social scientists. The definition today is a product of big power deliberation after World War II. So it's a product of deliberation between the United States, the Soviet Union, Great Britain, France, but it also had a lot of support in varying ways from countries of what we would call today the Global South. The definition itself, there's a few things I want to draw your attention to because it's important for our subsequent discussions. I want to draw your attention to this a little bit. You'll notice that the crime refers to genocide as the intentional destruction of a group in whole or in part. It identifies several groups which can qualify as victims of a crime of genocide, and there are 4 specifically. So it's national, religious, ethnic, and racial. It says ethnical, because that was the term used at the time. So basically, for someone to suffer as a victim of the crime of genocide, one has to be targeted because of one's membership in one of these groups. The perpetrator has to have this in mind. You'll also see that the term itself also refers to genocide as in whole or in part. There's no threshold, either in terms of numbers or proportions. The idea is that there's an intentional, relatively organized plan of group destruction as such. And you'll see a whole set of different crimes or acts which can qualify as genocide. And you'll notice here, I'm not going to go into them in detail, but I'll just draw your attention to a few points, that it begins, of course, with killing members of the group, but it also identifies a whole set of other types of really significant human rights violations that ultimately and concomitantly can reinforce one another and aim at the destruction of groups. So this is the definition we have today. It is the dominant definition. It's the one that's adopted in international law, and different policy advocates and human rights advocates and others use this definition in both prevention work and also in punishment work. There are a few points to just kind of draw your attention to that can sometimes be points of considerable contention or debate. One is the issue of intentionality. You'll notice that the definition refers to the intentional destruction of groups. So it's not merely widespread or relatively systematic mass destruction, but it has to be intentional. There has to be some kind of intentionality. You'll notice that the victim category list is actually pretty restricted. And this is partly a product of the debates at the time. A number of the powerful countries didn't want it to be too extensive. So for many of us who are social scientists like myself or historians, we often argue that genocide should be the intentional destruction of groups as defined by the perpetrator, because that's what matters. Not this arbitrary distinction, but this is the definition we have. And you'll notice the part about in whole or in part that I already mentioned. So this is the definition we have today. And really throughout much of the Cold War, there really weren't any significant prosecutions or trials for genocide. There were genocides that occurred. Scholars have some disagreements and debates over how many to actually include post-World War II during the Cold War. But you could imagine, for instance, the case of Biafra in Nigeria, the Cambodian genocide, also in East Pakistan or Bangladesh. These are kind of large-scale cases. But there have been others as well. And it's really only with the end of the Cold War that you see the development of a substantive, really extensive program of genocide prevention and punishment that emerges. And with the end of the Cold War, effectively, you no longer have the jockeying at the level of the UN between the US and the Soviet Union. So there's a possibility for the UN to step in and actually advance human rights protections. And genocide is an important part of this. So today what we find in the prevention world, I just want to say kind of 2 clusters of things and then I'll wrap up and I'll pass on to my colleague. Today what we basically find are kind of 2 things. We find that the architecture for both prevention and punishment is significantly developed and significantly more sophisticated, especially over the past 15 or 20 years, than it was in any period since World War II. And that's a big accomplishment. This is partly because of the emergence of the United Nations, but also the emergence of a global civil society movement that deals with all sorts of human rights issues. It's become sophisticated, it's become professionalized, and it's become internationalized. So we see today that there's a prevention architecture that includes not only a focus on genocide, but also other significant human rights violations, including crimes against humanity, war crimes, and so-called ethnic cleansing, which is not legally a crime, but it's usually captured by these other crimes. We see prevention work dealing with these different crimes. We refer to them as atrocity crimes, kind of language we normally use, occurring at the level of the United Nations, through regional organizations. My colleague will talk a little bit about the Organization of American States. Also occurring at the level of states and also in global civil society. And a whole set of tools have emerged to try to counter these types of challenges of genocide. I can talk more about those in the Q&A and I can kind of evolve a little bit more, but suffice it to say that it includes not only short-term and mid-term prevention tools such as negotiations, mediation, et cetera, but also trying to address structural problems of discrimination and marginalization. We do, however, face a whole series of challenges. And the challenges that we face today include not only a set of difficult cases, there are a bunch of hard cases around the world that we're confronting at the moment. Some of these you'll know if you read Washington Post or read the New York Times, or just watch the news. Myanmar, Sudan and South Sudan, Central African Republic, the DRC, Iraq and Syria, especially with the treatment of the Yazidi minority group, and also the Lake Chad Basin in West Africa. But there are also other cases of concern for those of us involved in prevention work, such as myself. including, for instance, just to identify two, Burundi, kind of keeps coming back on the screen and going away, but this is a major area of concern for genocide and mass killings, mass atrocities, and Cameroon, which outside of kind of the specific human rights community isn't something that's getting enough attention. So where does this leave us? I'm going to sketch out just a few challenges, and then I'll wrap up and pass it on to my colleague. The challenges we face today are actually quite significant. I mentioned that we have a very sophisticated architecture of prevention and punishment, but the challenges nevertheless continue to raise significant obstacles. Some of these challenges include a general move that's occurred over the past number of years towards more nationalist and chauvinistic types of ideologies around the world. This includes our country, starting at the very top, with a president who advocates nationalism at the expense of respect for other cultures and other societies. We also see a narrow conception of national interest that's not only among the more chauvinistic countries, but it's really kind of starting to crowd out thinking about multilateralism. We see a tendency more generally when it comes to prevention work to react too late, to wait till the fire is burning rather than dealing with the tinder before it's lit up. And the target countries are often institutionally weak and they're suffering from complex emergencies. What I mean by complex emergencies are situations not only of genocide and mass killing, but instances where you have massive refugee flows, you have weak states, you have very limited rule of law, you have outbreaks of disease, kind of things that humanitarian agencies deal with. So these complex emergencies reinforce dynamics of ongoing human rights violations. So what do we need? Sketch out a few things. We need more sophisticated understandings of how to mobilize political will. It's easy to talk about how political will is necessary and needed, but we need to disaggregate what political will is. Political will is not simply a cause of change, but it's itself an object of study that needs to be articulated and understood more clearly. So we need to mobilize political will more early. We need greater attention to root causes and responses, and not focus only on military interventions and humanitarian, which is what much of the focus is. And we also need to work a little bit more in depth at strengthening regional, national, and local actors, and not only expect change happening at the level of the United Nations. There's actually a lot of really important work that's being done right now as we speak on so-called focal points. That is, places where regional and national actors are actually taking on the mandate of prevention work, internalizing into their own system the rule of law and their own laws, but also working with regional civil society organizations. So I'm going to stop here. This is just kind of canvassing a little bit of where we are and where we came from. Hand it over to my colleague, and then we'll have Q&A.
Great. Well, thank you so much for that. Next, I want to introduce Professor Alejandra Gonza. She's a visiting scholar at Notre Dame this semester, and she's visiting from the University of Washington School of Law, where she teaches international human rights law and directs the International Human Rights Clinic. She holds a law degree from Tucumán National University in Argentina and a master's in European Studies and Human Rights from the Pontifical University of Salamanca, Spain. Her human rights practice and research focus on the inter-American human rights system, immigrant rights, human rights defenders, enforced disappearance, freedom of speech, arbitrary detention, wrongful conviction, and business and human rights. And at the International Human Rights Clinic at the University of Washington, she directs cases before the Inter-American Commission and Court of Human Rights, as well as other UN human rights institutions in foreign jurisdictions. And so I know that part of her presentation will discuss that concrete work that she does. So welcome, thank you.
Thank you very much for that kind introduction and the opportunity to discuss about genocide with the human rights perspective. What I want to share with you is a little bit of the discussions that was going on when I was working at the Inter-American Court on Human Rights, and Guatemala was the country that were taken before the court to discuss about genocide within what is not international criminal court, within the court that will decide international responsibility for human rights violations. It's going to be finding the government, state responsible for the human rights violations. So there's no possibility of international criminal response, individual criminal responsibility at the Inter-American Court of Human Rights. But for those who are not familiar with the Inter-American Human Rights System, it was built under the umbrella of the Organization of American States, and it's two bodies. One is the Inter-American Commission on Human Rights, which is in Washington, D.C., and the other one is the Inter-American Court of Human Rights, that is here in the picture, which is in Costa Rica. And the Inter-American Court of Human Rights is very important because you can issue binding decisions for the governments that recognize the jurisdiction of the court. Of course, the United States is not part of it, Canada is not part of it, and so it's a very Latin American court. So the cases of genocide that I will share with you today are the cases that were being discussed within this context in the Inter-American human rights system. Of course, around Inter-American human rights treaties, right? But the problem was presented early on, around 2004 was the first time the court will decide a case. But the problem was that in Guatemala, there had been an internal armed conflict that lasted for several decades. And after they were able to be done with the conflict, victims tried to find redress and accountability for genocide internally in domestic courts. Internationally, in Spain, for example, they couldn't go to Guatemala because of the amnesty laws or because the immunity, people became Congress people, etc. So they couldn't do it at home. After exhausting domestic remedies and trying to get redress domestically, they went to the Inter-American first the commission and then the court. The internal armed conflict was really damaging to Guatemala society. They had a commission finding that almost 200,000 people were killed or disappeared. And there was really an intention to get rid of the Mayan community, indigenous community in Guatemala. But they were never able to get this recognition from the government, even within the Truth Commission, to acknowledge that what happened in Guatemala could be qualified as genocide with all these elements that he highlighted before. So they really fought really hard. They went to Spain, they couldn't do it, they got a little bit of traction under the universal jurisdiction with those courts, and they almost got an extradition of Rios Montt, that those fall after the domestic courts, Guatemalan courts didn't accept that kind of jurisdiction, and it went exactly the same. So, but they also filed cases before the Inter-American Court. In 2004, it was the first time the court started deciding these cases, right? It was the first time the Inter-American Court of Human Rights had to deal with such massive numbers of victims. It was the first time they will find human rights violations around 600 or more people from one of the villages. Plan de Sanchez is called the name of the villages. But it was a very special case in several different ways. One of the reasons that genocide was not acknowledged by the Inter-American Court was that Guatemala was quick to accept responsibility for some of the human rights violations that were described in the case. By acknowledging that, they decided to go directly to remedies. And the Inter-American Court said, I don't have jurisdiction to say anything about genocide because this conflict started in 1996. And the Guatemala accepted jurisdiction of the court in the 80s. So there's a lot of time and a lot of acts and omissions from the governments that you're describing to me as genocide that I can't say anything about. So I don't have all the possibility of adjudicating genocide here. And that it was the first time they tried to do it, 2004. But there are several cases after that, and it was amazing how petitioners will come back with the argument of genocide and asking the court to recognize that for several different reasons. It was not until 2016, in the case of the village of Chichuac, that the Inter-American Court for the first time, without saying that they have jurisdiction over the crime of genocide, accepted that through interpretation of the right to life and different rights that are established in the International Human Rights Treaties, they can be content to the American Convention And actually, it did before with the crime against humanity and the crimes of forced disappearance of person without any problem, having jurisdiction over cases that happened before because it was considered a continuous crime. So the court said that they can use international criminal law to describe these facts. They continue saying that the problem is the temporal jurisdiction. And because they have that problem, they are not going to set the facts as genocide, but they are asking the government that since 1996, after they did the report of the Cruz Commission, the government of Guatemala knew that acts of genocide were committed or people were arguing that they were committing acts of genocide. And internally, the domestic investigation should go through that. So it's not enough for Guatemala to go to the Inter-American Court and say, we investigate all these massacres and we didn't apply international criminal law locally. One of the reasons that Guatemala said you can't do this in Inter-American Court was because Guatemala didn't have the crime of genocide in their criminal code. And the court said it doesn't matter. The crime of genocide it's even international customary law, and you don't even need to have it. It's used cautions, and you don't need to have it recognized. But even if you have it recognized after the fact, you can apply that type of crime in the new cases that the domestic courts are receiving. So the Inter-American Court started to push and push and push Guatemala to investigate and to address genocide. Of course, this didn't happen in isolation, right? What we've seen is after all these cases in the Inter-American Court, when the petitioners were not able to get the recognition of genocide, after they went to Spain and they were not able to do that, after they were trying hard, they were able to get a domestic decision that I think it was one of the first decisions against the former dictator, that it was domestic decision that was recognizing not only genocide, but it was that trial was incredible. Rios Montt, the dictator, was sitting there. I think they took testimonies, at least 600 people testified in that case. And in 2013, domestically, they were able to convict him and the chief of intelligence for crimes of genocide. But quickly enough, the Constitutional Court overturned that. And again, they continue fighting these petitioners, bringing more cases to the Inter-American Court, so they were able to have at least one court, domestically or internationally, acknowledging the existence of genocide. And you can see this is a picture that says in Guatemala, we did have a genocide. And that was the fight. It was a fight that they took all over the world. This is Rios Montt standing and answering questions about why he was defending what they did, saying, no, we didn't commit any genocide, we were just fighting against the guerrillas, right? And that was our power to do. The judgment, the internal judgment of genocide was extremely important. This is the judge that convicted Rios Montt. And she went to the Inter-American Court on Human Rights with that judgment. And she was part, of the expert witness, and she was there showing how difficult it was for the local courts in Guatemala to get accountability. And here you have different members of the Jujupac community, and there was different neighborhoods, there were different villages that were erased of Guatemala that went on. And after having all that, a bad decision, overturned decision in Guatemala, they went back to the Inter-American Court, asking the court to recognize that the Convention on Genocide can be used. And 2018, we recently had in September the decision, the final decision. They had to start over again the trial against Rios Montt in Guatemala. because of the overturn. They have to do it all over again. After doing it again, there's a conviction now, but Rios Montt is dead. And they found that the chief of intelligence of Rios Montt was innocent. There was not enough evidence to convict him. So you have this, the idea of justice. You have an amazing judgment. They have what they want, the recognition of genocide, but you have no one accountable. So what is accountability of human rights violations? What is what are the results of these long fights? Why these people continue fighting so hard? So that's where we are at now with what we think it was the most clear example of genocide in Latin America. That's one example. But the challenges of how do we apply the Convention on Genocide within the International Human Rights Court are not stopping there. The challenge here was trying to find and prove the intent of the government in really getting rid of the indigenous community group of the Mayan people. Now, there's another challenge that is coming. That it's a new challenge, but it's been discussed, right? Why we have to refer only to those groups? What happens when a government wants to get rid of political groups, to get rid of them all, to get rid of the opposition? And that was something that was brought by a Colombian case to the Inter-American human rights system. The Commission never accepted that the concept of genocide could include within these groups a political group. But in Colombia, Unión Patriótica, it was a political party that almost 6,000 people were killed because of the membership in that political party. And that case was recently filed by the Inter-American Commission on Human Rights before the Inter-American Court a few weeks ago. It's really new. The Commission is not saying that there's genocide, but if you read the wording of the acts on omission of the government, they match the concept of genocide and the idea that these acts were intended to the extermination of the members of these political parties. And that is now the discussion and will be the discussion because unlike the case of Guatemala, the court may have more temporal jurisdiction over the facts and the killings of some of the 6,000 members of the Union Patriotic Union. Patriotic Union, and that's where we are at now. The challenge is the court going to expand the concept of the groups now that they have the chance to do it or not? Why it's so important for these groups to say that it's a genocide and not just a crime against humanity? All those are questions that are now in need of a response from the International Human Rights Court.
Great, well, thank you so much to both of you. Great presentation. We're happy to open it now for questions. And as the moderator, I'm going to take the prerogative of the first question. And I'm going to just tie it in to something that each of you said. Professor Gonza, you were talking about how important it was to the plaintiffs to get a ruling that there had been genocide, and conversely, how important it was to the government to avoid that. And Professor Verdeja, you mentioned that while the UN definition of genocide is the operative one, there are other ways of defining what genocide is. So can you talk at a conceptual level about what is genocide, how might we define it, and why are those definitions so important to litigants in these cases?
Yes.
Thanks for that question. So I started off by having a slide up with the UN's definition for the convention, right, which is the intentional destruction of a group in whole or in part. It identifies those four categories of victim groups: national, ethnic, racial, or religious groups. What has happened basically is that definition is a product of these political negotiations, political deliberations right after World War II by the big powers I mentioned earlier. But for many scholars who work on genocide, particularly people who work in social sciences or are interested in studying the patterns and the onset group destructive violence, what we find, exactly as you were pointing out, is that very often there are other groups that are targeted for destruction who don't satisfy those criteria before victim captures. So for many scholars, we often use something like genocide as the intentional destruction of groups, the group as defined by the perpetrator. And the idea there is that one avoids the arbitrary distinctions, arbitrary classifications that excludes certain classes of people simply because they aren't being targeted because of their racial, ethnic, religious identity, et cetera, but they're being targeted for destruction according to some other criterion by them. The easiest examples or the best examples of this, I think, are the ones of political identification. That holds, in the case that you're talking about with Verdeja, it also holds probably in a very well-known instance in the case of Indonesia in 65, 66, with a target of around 500,000 to 800,000, 1 million people accused of being communists. But the point there is that it wasn't just about repressing them. It was about targeting and exterminating anyone identified as communist as such. And so what we find when you look at the actual study of violence, including genocidal violence, is that the definition of the victim group is often just as much partly objective in the sense it has historical antecedents and it's known culturally and socially, just as much that as it is kind of part of the thinking of the perpetrators themselves, because the perpetrators themselves create certain types of categories and then they destroy people accordingly. So this is why we don't always use the formal definition. The intentionality question is also very tricky. When it comes to law and prosecutions, one wants to be able one should be proving intentionality. There should be a high threshold of proof because these are really significant legal charges. From a social scientific perspective, though, from kind of two other perspectives, from a social scientific perspective, intentionality can be a little trickier to prove because intentionality tends to emerge over time. It is rare to have a program of genocide where there's a fully formed pre-existing plan of destruction. Rather, the plan of destruction emerges in the context of armed conflict or other situations. So it's a kind of dialectic. That's one point. And then secondly, from a preventive perspective, which is something I'm interested in, I do some work in the prevention community. My own sense is that if we focus too much on the UN definition for genocide, trying to figure out is genocide happening in Darfur or in Myanmar or wherever it is, according to the legal definition, you have to wait till too late before you can prove intentionality. So I don't think we should be in the business of trying to prevent genocide. I think we should be in the business of trying to prevent significant human rights violations. That's my thinking on that definition. So.
Yeah, for the plaintiff's perspective in these cases, it was important to get genocide recognized in the case for many different reasons. One is it's symbolic. One is the official recognition by a court that they were discriminated, that they wanted to erase from the story of their country. And that could be done with the genocide definition of intention in the extermination of the group. It's also legal because the threshold of intentionality is much more difficult to prove than the crime against humanity. And they wanted to go with the decision from the Inter-American Court to have that already recognized by international court and fight that threshold domestically. So using the international decision as one more evidence to support the idea that intentionality was proved. And of course, there's a political aspect of it, right? They want significant changes in their countries. And the reason that they do not have accountability in Guatemala is because the same people that violate human rights were in power. You have perpetrators that became presidents after the dictatorship. And I mean elected presidents, right? We talk about the judgment in 2013, an important judgment. We couldn't believe they convicted Rios Montt, and suddenly that was overturned. And the reason it was overturned, it was in one of the testimonies, the name of the president, of the sitting president of Guatemala, was put out by so many different witnesses saying that he was committing this horrible act himself, right? And so that's when they political will intervene in the judicial process and stop it completely. From Guatemala's perspective, they don't want the court to recognize that they committed genocide for similar reasons too, right? One is that if they have the jurisdiction to decide all these cases, the level of remedies and the level of victims will raise significantly. And so the remedies will be much more than the ones that they already have with a very limited temporal jurisdiction of the court. So instead of having thousands of victims within the Jamaican human rights system, we can have the 200,000 here that the Truth Commission recognized. So there's a significant. Then the other one is to avoid international criminal responsibility through the Convention of Genocide itself. We are not there. We didn't, because they were part of that convention way before they were part of the Jamaican human rights system. So they really want to deny genocide, and they want to say that was the internal war, and what we were doing as army and paramilitaries and all them, it's just fighting against the guerrillas, people that were armed, and it was like the use of force to do that. It was necessary. It's different than we went against with the intention of all these communities. The facts of the cases are horrible, right? Also, they wanted to try to avoid that several acts of sexual abuse and using sexual rape as an act of war was not adjudicated. The cases started, all the testimonies that came out through the Jamaican human rights system and in the domestic system pointed out to the use of sexual abuse and rape as an arm of war. And one of the elements of how they try to get this group exterminated, including women. So they were trying to stop all that. And the other one is the moral implications of that, and how the pressure that the governments can get, not only from the international community, but also their own citizens in Guatemala. So I think those are the several different elements that were out there. One party trying really hard to get that recognized, and the other one trying to avoid all the consequences that that recognition could have and had already. We cannot have, the case in Guatemala, the case of the judgment that, the domestic judgment that recognized the existence of genocide could never have happened without all these international human rights decisions. Those judgments came after these orders told Guatemala, you have to investigate what happened there. So these cases, all the names of these cases are part of Plan de Sanchez, those arrests, all those massacres were the ones that at the domestic level were able to get the symbolic conviction of genocide without a criminal pointed out in that.
I think you had your hand up first. And then...
My name is Peter Wallenstein. I'm at the Kroc Institute. Thank you. It's been a great panel. I think it's important to commemorate all these genocides in some ways. But I have a question to one case you haven't mentioned, and that's the Rwanda case. And there are two aspects to that. I mean, one is the inability of the international system to react in 1994, an unwillingness to call it a genocide, basically because the convention then more or less automatically demands action. So that's one part of it. The other is the government's use, that comes out, the Kagame government that comes out, who is today using the genocide as a way of explaining what they themselves are doing. So that sort of genocide, in a way, becomes a way to legitimize the authoritarian regime. So I wonder if you could reflect a bit on this, probably Ernesto as well.
Why don't we take a couple of questions and then you can respond.
As you know, the Genocide Convention not only prohibits genocide, it actually has an article that obligates all parties to prevent it. It's a duty to prevent it, not to do. And I'm just wondering if that, because that's fairly unusual in human rights treaties, this duty to prevent actually relates to Peter's question too, but what's the historical, political, or legal experience with that provision? And for example, as a US citizen, am I entitled to a legal US foreign policy, which includes a demand that the US government recognizes its duty to prevent genocide?
So two very, very difficult clusters of questions. I think first of all, so Peter, you're absolutely right. I didn't mention Rwanda. There are sadly many cases that we could kind of touch on. In terms of thinking about the unwillingness / inability of the international community to respond, I say it like this because I think sometimes we talk about international community as if it's a given, but it's actually something very fragile that has to be sustained, right? So it is what it is. I think in that case, there were a couple of different things, several different things going on. One was different countries had particular interest in not intervening, like the United States and several European powers, as well as other African powers, but particularly the US and certain European powers. In addition to that, there was also a problem, it was almost like an epistemic problem. There was an inability to understand what was going on, in the sense that for many people who were observing what happened in Rwanda in 1994, when the genocide started in April, there was a sense that this is just either a return to civil war, I say just, which is unfair, but that's the way it was saw or seen, or it's just typical conflict of Central Africa. It's just kind of, it's not that big of a deal, it's just more of the same. In other words, it was seen as something within the paradigm of civil war rather than the paradigm of genocide. And that changes your whole view when you have a vision of something where you kind of put it epistemically in the wrong category. But there was, of course, a lot of interest of countries not to use the language genocide. And the US in particular actively worked not to use the word genocide. So one way to understand Rwanda, and also what was happening in Bosnia as well, genocide and ongoing conflict in Bosnia more broadly, is that both of these events serve to catalyze a new phase or a new movement of genocide prevention and genocide response. And that's where we get the responsibility to protect. That's where we get this modern day architecture of genocide and mass atrocity prevention. And so I think it's had really significant impacts there. And the architecture that exists today, the global architecture for prevention, everything from very, very large scale institutionalized global architecture, all the way down to civil society efforts at the international, national, and subnational levels, is very robust, though it's under a lot of pressure now because of changes in global politics. We'll merge towards nationalism shortly. But it is much more sophisticated than it was in '94. We just didn't even have kind of a good way of thinking how to prevent these things. So Rwanda has been instrumental in that. You are absolutely correct that President Kagame in Rwanda, who led the insurgent force that brought an end to the genocide, has continued to use the genocide to justify, the older genocide to justify his own authoritarian rule. That's separate from the question of whether Kagame and his military forces have committed a genocide in eastern DRC. I put that aside because that's a tricky question, though there is a UN report in draft form that argued that there were good reasons to investigate Kagame's military forces for genocide in eastern DRC. That was in a draft report of about maybe 10 years ago, and then it was taken out in the final document because of political pressures. But it's absolutely correct. Authoritarian governments often use past atrocities to justify their own authority. I think Rwanda is probably pretty fragile in the scheme of things. If Kagame were to be assassinated or just die or whatever, something along those lines, there's no real plan of transition, and the country could experience significant violence and conflict. It doesn't necessarily mean a genocide, but it's fragile. It's a fragile country. In Rwanda today, when you go to Rwanda, what you find is that the period of violence of April 1994 and onwards is referred to formally as the genocide against the Tutsi. There's no discussion of violence against the Hutu, which did occur, even by the Hutu extremist government. It's been written out of the history, and that's deeply problematic. So I think you're absolutely right to bring up this complicated case. Bob, your question about whether an American citizen has a right to demand this kind of status of prevention is, you're absolutely correct that the UN Genocide Convention stipulates that the
international community has a duty to prevent genocide. It's kind of built into the definition or the title of the document. However, most of the document really doesn't deal with prevention, right? The convention actually largely deals with punishment, laying out the crimes and obligations to prosecute and all that kind of stuff. It doesn't talk that much about prevention. In addition to that, I think it's actually, the convention really raises profoundly a difficult philosophical and practical question, which is, what is duty? We can think of duties as perfect duties, right? Where there is, people have a right, and there are obvious agents who are enjoined to respect that right. So in American domestic laws, the government has a right, has an obligation to respect our rights as citizens, et cetera. But here we're talking about an imperfect duty because it falls on the international community, and it's not clear on what that actually means. In practice, sometimes it's the Security Council, that's kind of the go-to place, but it may also mean regional powers, it may mean former colonial powers. So the imperfection of the duty, the mismatch between duty and rights, has allowed a lot of countries to shirk responsibility for preventing or acting more proactively in a multilateral way to prevent genocide. Again, I think there have been efforts to try to address this by focusing on multilateral efforts at the regional level. So you're building capacity, but also kind of concern and responsibility at the African Union level, at the OAS level, et cetera. And that's been promising. The African Union, for instance, today has what I think is actually a pretty sophisticated program on conflict prevention and conflict forecasting that's been developed. Now, it doesn't mean it has the support of the actual governments, but it's become much more sophisticated, and they have a really good sense of what's happening in Africa in a way that didn't exist 15 years ago. So there are efforts at that. Do American citizens have a right to demand that of their leaders? I think absolutely so, but I don't see any political traction on it.
Just a technical follow-up. That duty, is it specified only for the international community, or is every party as a state obligated to fulfill that duty as an individual state? I mean, it doesn't just wait for the international community to act, does it?
That's correct, but so, and we have an attorney here, so I'm sure you could, a law professor, so I'm sure you could add more to this. It's ultimately the Security Council, right? That's the first place where this goes, because the Security Council is in charge. I mean, I'm talking to someone who's like written books on this. So. The irony is not lost on me. But it first of all falls on the Security Council. But there is a possibility of relying on multilateral efforts or even kind of particular countries. When India invaded East Pakistan and made the argument that they were preventing genocide, that was partly true. They invaded for other reasons as well, or Vietnam and Cambodia. So it can fall in particular countries, but it does raise questions about the status of the Security Council as kind of the first agent to intervene. Is that how you would see it as well? This is the general understanding of this.
Yeah, well, my answer is kind of more direct, is yes, the US government has the duty to prevent. The problem is how we give content to that duty and how we enforce that duty as an American citizen. You mentioned the Security Council is a great example why we are not that great at preventing it, because the Security Council reacts too slow because of the political interest of the permanent members of the Security Council. And permanent members, that they do have the obligation to prevent that they don't want to address it because of the political consequences of getting the allies mad and things like that. And we've seen that happening several times. There's also the Human Rights Council now that has more and more will to analyze under the human rights framework genocide in a more concrete way. Recently, they created a task force for investigating and send a fact-finding mission to Myanmar and to analyze that. And I was surprised that the report, they didn't have the mandate to investigate genocide, but they came out with a report that their findings were really incredible. They said that they found elements that are matching the elements of the Genocide Convention, and so they put out all these recommendations to the international community. So in terms of technically, yes, we have to prevent. How do we as citizens trigger the enforcement is very difficult at the international level, which is the one that I know. The other way is that but it's very difficult to get when you have political opposition, is that they bring these human rights concerns through, instead of when there's a permanent member that they don't want to put a topic out there in the Security Council and it's not within the Security Council. Human rights advocates brought to the Security Council through the ARIA formula way of discussing this with the human rights perspective. But you're absolutely right. I think within the human rights mechanism and international criminal court, the duty of prevention is very weak in terms of how to enforce it. But civil society is really strong and creative, and I think we need to continue pushing because the reality is very daunting.
3 questions, and then I'll take us on.
So I mean, this is related to what you guys already talked about, but so we talk about the international community and its responsibility, but I would be interested in hearing more about sort of what states are doing individually as states. So take the Genocide Accountability Act of 2007 or the Mass Atrocities Act of 2008 in the United States. So what are states doing, or even below states, to actually bring into domestic law these international obligations in ways that actually might be more effectively realized by the citizens of those states?
My question is about what are the, could you talk about the political consequences of a legal finding of genocide, especially in the context of would it necessarily lead to a triggering of a right to external self-determination for that group, if that group also can be considered a people? And how far do these political consequences impact the kind of pressure you have beforehand, before a decision is made on whether genocide happened or not, or in prevention of genocide? It's kind of political pressure it creates in the international community by states to push back and not investigate and just try to stop the killing, as opposed to try to have any sort of accountability for genocide.
Yeah, we stand, I think, at a moment in time where we have to contemplate not only the destruction of a group, whether defined in the Genocide Convention or the way that you talked about, Professor Verdeja, but we have to, I think, contemplate the possible extinction of the human species through mechanisms like climate change. And there is obviously, I mean, this is news to nobody, but there is a temporal delay between actions now and consequences later, such that President Trump or the President or CEO of General Motors can undertake mechanisms that make climate change, significant climate change and possible human extinction more likely. But they won't pay the cost for it. And so I find myself questioning the only thing that will make them perhaps question their actions is if we make their descendants pay the consequences for it. For example, President Trump's children being stripped of all their assets in 20 or 30 years because of the effects of climate change already happening in places like Bangladesh. And my question is there a legal mechanism already in place that we can use as a model to argue that this is justified in law and not some kind of legal innovation which has kind of Stalinist overtones, for example? But that's my question.
Well, I will tell you about your question about what states are doing and what they have done after the International Human Rights Court ordered different reparations. One thing that we've seen is the change in criminal law. They started to permeate international criminal crimes within the domestic criminal codes. And then getting the cases that were coming to that type of crime. They also designed different type of remedies around, collective remedies that could go through indigenous communities particularly. And some of the Latin American countries are part of the International Criminal Court, so they recognize the jurisdiction of the court and all the crimes that the International Criminal Statute bring definition to. I mean, they permeate all those concepts at the domestic level. So I think that's one very important thing, because now at least they have domestic legal avenues to push for the recognition of genocide through regular institutional accountability mechanisms of those countries, right? Of course, there's elements of truth commissions and things like that that were significant efforts considering they were done right after the conflict. It was very difficult to put those together, but they did, and that was important here. So that's my answer to that one.
No, yeah, yeah.
No, go ahead, go ahead.
Do you want to answer some of the other ones too, or?
To yours, I think it's, I don't know exactly if I understood your question, but I do think that it would be good to analyze all the corruption mechanisms that are going on internationally, how to tackle corruption, and how to get back all these elements of corruption. I'm not a kind of expert, so I have no idea how to do that, but yes.
So thanks for these questions. This is a wide range of questions. I think, Aaron, starting with your questions, what are states doing at the national, but also subnational, what's going on? So drawing on Alejandra's earlier point about civil society, there's a lot of work happening at different levels of civil society, whether it's transnational civil society or kind of domestic or even very localized civil society groups. That's one way to slice and dice it. Another way to think of it is civil society groups that are broadly about social solidarity, inclusivity, promoting tolerance, et cetera, and then civil society organizations that are highly professionalized, dealing with certain questions. So kinds of human rights organizations that you've worked with, for instance, and others here as well. You put these things together and you find that the patchwork of civil society efforts at addressing what I would consider to be atrocities prevention, genocide prevention, is actually really sophisticated. Part of it, I think, is lost on us sometimes because we use different terms for communities of people who actually overlap in various ways. You have the human rights people, you have the transitional justice people, you have the Truth Commission folks, you have the genocide prevention folks. But for instance, in atrocities and genocide prevention, one of the important steps is looking at root causes and structural violence. That involves speaking to people who work on development or on racism or on discrimination, et cetera. So there are a lot of practical areas here for overlap. What I find is that in terms of what's going on under the hood, so to speak, at kind of these other levels, is there are more and more efforts at monitoring that have become really sophisticated. So monitoring as part of prevention tools, early warning, understanding what's happening in communities. Technology has aided this enormously. So to give you a concrete example, in Kenya and Tanzania, there are a number of human rights organizations that use new software platforms and social media in order to be able to understand what's going on in their communities in real time. There's a human rights organization in Canada called the Sentinel Project, started by people straight out of college about 7 or 8 years ago, who gather that information and have an ongoing map, like a heat map of what's going on. So it's not about external actors coming in and saying this is what you need to do. In fact, it's external actors that are helping facilitate the combination of these different sources of information, but also help build capacity at the community level. Those types of endeavors are things that didn't exist 15 years ago, right? So there's a lot of work like that at a sophisticated level and monitoring levels. There's a lot of work that's being done at thinking through about how promoting anti-discrimination, promoting democratic responsiveness ties to atrocity prevention. There's a lot of work being done. I think this is where it's going to go in Myanmar if it takes off. And Myanmar is a really hard case. But rethinking the actual legal system, right? So Myanmar, as I'm sure you know, part of the problem is that there are formalized laws that systematically deny citizenship to whole classes of people who've been there for generations. They're just not Burmese citizens. And that means that they don't have any legal protection. The old Han or Ret argument that you're a stateless person, the first right is to have rights. So there's efforts at kind of thinking that, but that you need lawyers for that. You need people who are highly professionally trained. And then the last cluster I'll refer to, because we've talked already a bit about the law, the last cluster of responses I'll refer to are efforts at trying to develop capacity in terms of awareness and monitoring, but also responsiveness at national levels. In Latin America, this has become really sophisticated. This is the focal point stuff I talked about, where instead of relying on the UN or kind of a special office of the UN called the UN's Special Advisor for Genocide Prevention and Responsibility to Protect. It's UN, so you know it's really long. Too long to tattoo. Joke. So rather than relying on the UN at that level, you effectively have the really detailed work being done at these other national, regional, subnational levels, because that's where the significant knowledge of what's going on is really happening. And that effort, I think, has a possibility of paying serious dividends. It's happening in Africa a little bit. Latin America is pretty far advanced. Parts of South Asia are kind of coming on board through ASEAN, but these are different kinds of atrocity prevention efforts. As far as what are the political consequences of a genocide determination, it kind of depends on what you mean by genocide determination. There's a legal determination, right? So say a court case or something like that. At the international level, there are relatively few of those, though they do exist. At the national levels, there's somewhat more, but different countries in terms of domestic law have different definitions of genocide. They write their laws for their own particular reason, so that they have to harmonize it accordingly, etc. But there's a legal consequence issue, whether it, for instance, generates a right to reparation or a right to separation, as you were saying. Then there's the political consequences more broadly as to what are the impacts there. I think it's really hard to generalize, to be honest with you. I don't think there's one particular finding, one particular direction disclosed. The Yazidi in northern Iraq, who were effectively the targets of extermination by ISIS about 3 or 4 years ago, it was recognized that was a genocide. The EU recognized it as genocide. Germany recognized it as genocide. But today, Yazidi refugees, I know this just because I've heard about it recently, Yazidi refugees in Germany are being told that their asylum cases are likely to be turned down because there's no genocide happening, even though there's significant violence that they could still suffer if they're returned. So it's hard to generalize too much. As far as the human extinction climate change point, so I think here's a call for kind of conceptual clarification, right? You're absolutely right. So the issue of climate change and its response in terms of climate justice, this is one of the big looming challenges. And climate change leads to all sorts of other types of issues that exacerbate armed conflict, et cetera. The research is complex, but we know we have pretty good reason to believe that. But even here, the language of the we is tricky, right? What does it mean for we to take resources from them, to take it from the Trump children, whatever? These types of terms, and these types of conceptualizations, I think a lot more work. At least that's my sense. I'm not an expert on it. And I also think that we need a different term or a different concept for the extermination, the extinction of the human race that doesn't rely on genocide. Genocide is kind of something else. Genocide can happen under those circumstances, but we need a different concept that captures the complexity of that and its own dynamics. However, having said that, I think we are likely to see more armed conflict, including as a subset genocidal violence, in areas that already have low levels of resilience, weak governance, and are exposed to drought, famine, all those kinds of things. The Sahel is the classic example of this. So that's what we're going to be seeing more problems.
One more thing that within the Jamaican human rights system they've been trying to do to address more of the things that are happening now, instead of waiting 20 years and find accountability later on, is that they created different groups of experts appointed by the commission to go in when the government and the country is in trouble. So they created these groups of experts, and they were able to go in Nicaragua, for example, right now at the moment, and start analyzing and assessing the human rights situation right now, issuing precautionary measures and decisions, and visiting and engaging with the government, engaging with civil society, why this is happening in Nicaragua. That's one effort. Another effort is around enforced disappearances of persons that are occurring in Mexico. Believe it or not, in Mexico, during the democracy of Mexico, we have at least officially recognized 30,000 people disappear. And every day more people disappear in Mexico. So they created a group to analyze one very feasible case of 43 students that disappeared. And the government didn't want to interview the army that were involved in the disappearance of these 43 students. So this group went in, and it was created in an agreement with the government of Mexico. The government of Mexico let this group in. They gave them access to the criminal files. They made independent assessment of all the lies that the Mexican judiciary were putting out in those crimes. They pushed for investigation of the army people and interviewing of the army people. They made independent reports. They put a lot of supervision and oversight around the enforcement appearance person. Those are new efforts. They don't have any legal procedure that you can follow to get those in the country that you're interested on. But it seems like the pressure of the civil society with a combination of using the legal mechanisms that are available internationally, like precautionary measures, could trigger an agreement with the government that they don't let anyone in, and suddenly they let these experts on the Inter-American Commission in to assess gross violation of human rights in their own country. So those are things that I wanted to highlight as good efforts, I think.
I think our time together has come to an end, but can you please join me in thanking our panelists?